How do I get my workers on time without delay? Many factors impact the timeliness of an application. The first thing we advise at Farmer Law PC is to file as close to 75 days before the start date as possible. The DOL's range for filing the original ETA 790 is 60 to 75 days before the anticipated date of need. In order to file a petition if you are a fixed site owner, you will need to have the worksite addresses, the job site addresses, a clear agriculture job description, hours per week, hour schedule, wage rate, the number of workers it will take to perform the work, and a certificate of insurance. If you are a farm labor contractor, you will need to have everything listed above in addition to your farm labor contractor certification, certified drivers with FLCEs, farm labor agreements and owner agreements establishing your permission to be on the site to provide services to the farm owner, and you are required to have a surety bond for each petition filed based on the number of workers requested. Once you provide the documentation to Farmer Law PC for your petition, we internally move the petition forward with a high sense of urgency. The most common hurdles that have the biggest impact on worker arrivals are 1. The farm labor contractor certification for housing, transportation, or obtaining authorized drive time. The OFLC office in San Francisco is responsible for certifying the FLC and FLCEs, but their office tends to be understaffed and has weeks-long waiting times for new applications. If the process is not started well before 60 to 75 days prior to the start date, a petition can run the risk of not getting certification while the FLC and FLCEs are pending. A second hurdle is slow turnaround time in providing documentation from either client to agent or agent to relevant government entity. At Farmer Law PC, we internally shoot for a 24-hour to 48-hour turnaround time on requests made to us by the government. In order to meet these deadlines, a successful client will also turn around and produce documents as quickly as possible. The most standard timeline the government sets is 5 business days, which is sometimes necessary if the request involves more than ordinary document collection. But on average, the documents requested can be quick to produce if they are prioritized. Housing is a common issue because it must be secured over a month prior to the date of need, and the addresses including apartment or unit numbers are needed when starting the petition application. In addition to having the correct address at the beginning of the filing, the DOL requires that the housing pass inspections before issuing a certification. The preferred timeframe to have a housing inspection approval without potentially delaying the arrival of your workforce is at least 32 days prior to the date of need. Fourth, the DOL allows you to file the ETA 790 up to 60 days prior to the date of need and allows you to file the ETA 9142 up to 45 days prior to the date of need. Responses to government requests are usually set at 5 business days, and the recruiting report deadline is set by the certifying officers typically a week out from the notice of acceptance. If an employer and an agent go through the motions to hit the minimum dates set by the government, it can add up to not receiving certification at the preferred 30 days before date of need. Without a certification date around the 30 days before start, it makes it difficult to book timely appointments, considering the consulates can take anywhere from a couple days to multiple weeks to process workers, and this usually depends on the country and the consulate you choose. Lastly, petitions rely on working with the state workforce agent in the state in which you are filing, as well as the Department of Labor's Chicago National Processing Center, the Department of Homeland Security's USCIS division, and the consulate in the country you choose to process your workers. Government shutdowns, defunding of departments, a particularly slow or inexperienced analyst, natural disasters, unrest or violence in a country, etc., can all impact the speed at which you get your petition certified and approved for booking appointments. The best bit of advice for getting your workers on time is to work with a partner who understands the impact a delay on your farm and or business operations, and who understands the business and reputational implications of not having the workers you need to get your work done and meet your commitments. At Farmer Law PC, we have found that a sense of urgency, quick internal turnaround times, and follow-up with the government agencies can mitigate some of the risks of the external factors mentioned above. The definition of corresponding employment is the employment of workers who are not H-2A workers by an employer who has an approved H-2A application for temporary employment certification in any work included in the job order or in any agricultural work performed by the H-2A workers. To qualify as corresponding employment, the work must be performed during the validity period of the job order, including any approved extension thereof. This means that a worker could potentially move in and out of corresponding employment. As a hypothetical, an employer in Florida is using 2021 AEWR wage rates of $12.08 per hour for a job order petitioning for 12 workers to harvest crops and other agricultural duties. If the employer employs year-round workers who sometimes help to harvest the crop or overlap in the same job description that is in the job order for the H-2A workers, the U.S. worker will then be considered a corresponding worker. In the event you have identified someone as a corresponding worker, the corresponding worker will need to review and acknowledge the job order prior to the date of need listed in the job order. The corresponding worker will also need to be paid at a minimum the rate listed on the job order. Even if this worker identified is an $8 an hour employee who typically just sweeps your shop, but sometimes pitches in with the job duties listed in the job order, that worker will be established in corresponding employment for the validity period of the job order and will need to be treated in the same manner of the workers on the job order. Disclosure of the work contract becomes relevant once you have identified corresponding workers. The employer must provide to an H-2A worker no later than the time at which the worker applies for the visa, or to a worker in corresponding employment no later than on the day work commences, a copy of the work contract between the employer and the worker in a language understood by the worker as necessary or reasonable. For an H-2A worker going from an H-2A employer to a subsequent H-2A employer, the copy must be provided no later than the time an offer of employment is made by the subsequent H-2A employer. What is a recruitment report and what are my obligations as the employer? The employer must prepare, sign, and date a written recruitment report. The recruitment report must be submitted on a date specified by the certifying officer at the Chicago National Process Center in the Notice of Acceptance and contain the following information. 1. Identify the name of each recruitment source. 2. State the name and contact information of each U.S. worker who applied or was referred to the job opportunity up to the date of the preparation of the recruitment report and the disposition of each worker. 3. Confirm that former U.S. employees were contacted and by what means. And 4. If applicable, for each U.S. worker who applied for the position but was not hired, explain the lawful job-related reason for not hiring the U.S. worker. The original recruitment report is due typically within a week after the employer receives a notice of acceptance from the National Processing Center. If the employer finds qualified applicants for a position prior to submitting the original recruitment report, the employer will list the employees who were hired. For every person hired in this phase, the DOL will reduce the number of workers certified on the petition by that number. In addition to the recruitment report submitted to Chicago NPC, the employer must continue to maintain the recruitment report throughout the recruitment period, including the 50% period. The updated report is not to be automatically submitted to the department, but must be made available in the event of a post-certification audit or upon request by authorized representatives of the Secretary. The 50% period is a defined period that is established when the State Workforce Agency certifies an original ETA 790. An employer must continue to accept referrals, walk-ins, and any applicant for the position, as well as continue to document each contact's name, information, if they were hired or if they were not hired, and why. In the event you hire someone, they become a corresponding worker and will need to receive and acknowledge the job order prior to the date of need and will need to be treated in the same manner as your H-2A workforce. The recruitment report should be updated through the 50% period, and a final recruitment report should be signed and stored for future audit requests. To get a broad overview of the expenses an employer is responsible for within the H-2A program, it can be broken down into categories. Number 1, housing expenses. Housing expenses will depend heavily on geography as well as costs of meals if kitchen facilities are not provided in the housing. Number 2, transportation to and from their hometown, to and from a work site on a daily basis, to a grocery store at least once a week if providing kitchen facilities, and to a laundromat if washer and dryer are not provided in the housing. Number 3, fees associated with agents and attorneys to file the petitions with the State Workforce Agency, the Department of Labor, and the USCIS. The Department of Labor charges a certification fee of $100 plus 10 times the number of workers you are requesting. The USCIS currently charges $460 for each I-129 sent. The U.S. Embassy charges $190 for each worker they have to process. Number 4, consulate processing fees for agents and attorneys. Number 5, the employer must provide to the worker without charge or deposit charge all tools, supplies, and equipment required to perform the duties assigned. Number 6, compliance costs associated with compliant onboarding and employment verification, proper documentation and record keeping, earnings records, reimbursable expenses, finding and setting up housing for inspection, and maintaining housing specifications.